Mr. Speaker, I wish to continue my speech on Bill C-51. As I alluded to before question period, the most substantive part of Bill C-51 deals with amendments to the criminal code related to Canada's sexual assault laws. I support many of the amendments to the criminal code brought forward in Bill C-51, including those amendments that clean up the criminal code by codifying law determined by the Supreme Court of Canada, including in the J.A. and Iwanchuk decisions. That being said, there is one area of Bill C-51 in terms of changes to sexual assault laws that cause me some concern. And that area of concern relates to the defense disclosure requirements. Bill C-51 would require that in order for the defense to tender evidence in terms of records that relate to the complainant, that they would have to bring an application to the court. In other words, records that relate to the complainant would be deemed inadmissible unless the court determined otherwise. Such an application would have to be brought prior to the trial. Moreover, the complainant would have the right to counsel and would be a party to that application. There are a number of concerns that I have with that. First of all, Mr. Speaker, the definition of records is very, very broad. The type of records, the scope of records that would be captured, again, is just about any record related to the complainant. That would include, Mr. Speaker, potentially joint records, records that both the accused and the complainant otherwise have a right to access. It would include potentially records that are subject to Crown disclosure, that are in the control of the Crown. It could include, Mr. Speaker, records that were ordered subject to a third-party application. And so, Mr. Speaker, when we're talking about the breadth of records that would be captured, we could be talking about, in some trials, thousands and thousands of records that would be subject to such an application. Now, Mr. Speaker, what that will do is result potentially in delay. And I have to say, in addition to the potential for delay, the timing of the application is of some concern. The application would have to be brought prior to a trial. Now, what is the problem with that? Well, one problem is that there are often issues that arise in trials that are not necessarily foreseeable prior to the trial. And so, from a practical standpoint, what that will mean is that there could be records that do not appear to be relevant prior to the trial that become very relevant as a result of an issue that arises in the course of the trial. So what that will mean, Mr. Speaker, inevitably, is that there will be, of course, applications brought prior to the trial, but in those instances where records become relevant that were not necessarily obvious or apparent prior to the trial, it will result in the need for mid-trial applications. That will mean the adjournment of trials and a delay in the administration of justice. And, Mr. Speaker, that is particularly concerning in light of the Jordan decision. In Jordan, the Supreme Court determined that delay is presumptively unreasonable where 18 months pass between the laying of charges and a trial for matters before a provincial court and 30 months in the case of matters before superior courts. Over the last while since Jordan was rendered, we have seen dozens and dozens and dozens of serious criminal cases thrown out of court, cases involving everything from murder to sexual assault to other violent offenses. In addition to that, Mr. Speaker, we have seen hundreds, if not thousands, of perfectly prosecutable cases, or cases that would otherwise, but for Jordan, be perfectly prosecutable, dropped as a result of delay. And so the prospect of adding further delay to a system that is stretched to the limit is problematic. What it is going to mean, potentially, Mr. Speaker, is that more sexual assault cases are going to be thrown out than otherwise, based upon Jordan at present. And I say that that is less than comforting to victims of sexual assault. It's less than comforting. It's frankly unacceptable, Mr. Speaker, that we could be opening that possibility. And it certainly runs counter to the purported objectives of Jordan, which include, of course, ensuring that victims see justice. Then, Mr. Speaker, I believe that there have been some legitimate questions that have been raised about the appropriateness of a complainant to be a party to such an application with the right of counsel. Very often in sexual assault cases, the outcome of the case rests on the credibility of the complainant. And the fact is that most complainants are truthful, but not all complainants are truthful. In some exceptional circumstances, complainants are not truthful. And the effect of this means that a complainant will gain insight into the defense's case and potential lines of cross-examination. This, in turn, Mr. Speaker, could undermine trial fairness in a significant way. Okay. And I say, Mr. Speaker, in closing, that I would like to quote the caution, the recent caution of Ontario Superior Court Justice Malloy in Niznik at paragraph 17, where he stated, quote, "Although the slogan, 'Believe the victim,' has become popularized of late, it has no place in a criminal trial. To approach a trial with the assumption that the complainant is telling the truth is the equivalent of imposing a presumption of guilt on the person accused of sexual assault and then placing a burden on him to prove his innocence," unquote. I think that pronouncement of Justice Malloy is something that we, as members of Parliament, need to be mindful of as we try to strike the right balance between ensuring that victims of sexual assault are protected and that their dignity and privacy is upheld with the right of the accused to make full answer and defense. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Whitby.
Thank you, Mr. Speaker, and I'd like to thank my honourable colleague for his comments. And Mr. Speaker, I think we could all agree on the merit of this bill, and so I do appreciate his insightfulness when it comes to talking about the legalities here. But I was somewhat disappointed that the member, in the opening of his speech, would take this opportunity to attack our government and be partisan, particularly on this very sensitive and important bill as it relates to consent and victims' rights. We have heard members on this debate on both sides of the House talk about how this bill would give women confidence to come forward, and we've demonstrated our capacity to really work together in this House. We unanimously passed a motion put forward by the interim opposition leader. So I wonder what the member would say to women in his riding about the benefits of this particular bill as it pertains to them specifically.
The honourable member for St. Albert, Edmonton.
Mr. Speaker, there are a number of good components to this bill related to changes to sexual assault laws, including codifying the Wanchuk decision to make it absolutely clear with respect to mistaken belief, that the defense of mistaken belief based upon mistake of law cannot be put forward, Mr. Speaker. The bill also is positive in that it codifies the JA decision to make clear that under no circumstances can a complainant be found to have given their consent on the basis of when they're in an unconscious state, Mr. Speaker. So these and other changes are positive aspects of the bill. But that being said, I do have serious concerns about the defense disclosure requirements. These are very real concerns. They are substantive concerns. They raise charter issues, and they go to the heart of trial fairness, Mr. Speaker. At the end of the day, it is fundamental that complainants are protected in our system, but it is also fundamental to our justice system that accused persons have the right to make full answer and defense. That is fundamental to getting to the heart of the truth in a particular case and to guard against wrongful convictions.
Questions and comments. The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. I wonder if the member can speak a little bit to the Section 176 that this bill had initially proposed to remove, and it now seems that that there's a willingness on the part of the government to back away from this. But this wasn't a concession that came easily. Obviously, the member will know that he and other members of our official opposition worked very hard. There were many Canadians who became active and mobilized across faith communities to show the government that it doesn't make much sense to, on the one hand, talk about a rising climate of hate and fear, to, on the one hand, talk about risks that faith communities might face, but on the other hand, to propose to remove the one section of the criminal code that actually specifically provides protection for the practice of faith in Canada.
The honourable member for St. Albert, Edmonton.
I thank my friend and colleague, the member for Sherwood Park, Fort Saskatchewan, for that important question, and I want to acknowledge the work that he did as being one of the first members to flag that Section 176 was sought to be removed by the government in its initial draft of Bill C-51. And he is quite right that it took a lot of pressure for the government to come around and do the common sense thing and the right thing about a section of the criminal code that is not unconstitutional, that isn't redundant, and that has been used regularly. Not regularly, but certainly in several cases, including most recently involving an Ottawa woman who vandalized a religious statue. And he is quite right when he speaks about a climate of fear and a climate of hate in which persons have, and churches and synagogues and mosques have been targeted by people who are hateful. And we have seen that recently with a number of acts of vandalism at Ottawa area synagogues and mosques. We have seen many instances of this. And so not only was it substantively the wrong thing to do, the timing couldn't have been worse. And it is really inconsistent with the government's purported commitment to ensuring that measures are taken to deal with and address serious issues around hate being perpetrated and individuals being targeted on the basis of their religion or other characteristics.
And comments? Question commentaire. The honourable member for Central Nova.
Thank you, Mr. Speaker, and I enjoyed the very legalistic approach to my honourable colleague's remarks, and I come from a similar professional background and a similar vintage as the honourable member. But one of the things that I've been able to do, has been a complete privilege of mine since I arrived in this place, is to serve on the Status of Women Committee. And when we did a study on ending violence against women, particularly against young women and girls, some of the testimony that we heard was about the dramatic underreporting of sexual assault in Canada and how ill-equipped our legal system is to deal with those who do muster the courage to come forward. I view this bill to be a positive step that will not only encourage more young women who've been victimized and have survived sexual violence to report, but potentially leading to more convictions where that sexual assault is reported. Does my honourable colleague agree or disagree that it will lead to more convictions in circumstances where a sexual assault has been committed?
The honourable member for St. Albert, Edmonton.
Mr. Speaker, I believe that certain parts of Bill C-51 help clarify the law around sexual assault. One example of that is in the area of evidence that is tendered with respect to the twin myths, Mr. Speaker. This bill makes it clear that that evidence cannot be tendered under any circumstances, and that is good because there has been some confusion in the case law with respect to Section 276 sub 1 and then another subsection 276 sub 2 and subsection 3 that has resulted in some cases, trial judges basically having a balancing test. This bill would eliminate that to make clear that if evidence is being tendered to on the basis that a complainant, as a result of her sexual history, is less believable or more likely to consent, that under no circumstances can that evidence be tendered. So that is a positive step. But the problem with this bill is that it is an omnibus bill. It relates to matters that are unrelated to one another. And so there are parts of this bill that are very positive, but there are other sections that are frankly very problematic, including with respect to the defense disclosure requirements.
Questions and comments? The honourable member for Winnipeg North. We have 2 minutes left, so a minute for the question, a minute for the answer, and I think that should be great.
Thank you, Mr. Speaker. I'd like to pick up on my colleague from across the way's comments when he makes reference to Omnibus bill. What we have before us is a number of changes, and those changes come in good part as a result of courts' decisions and reviews that have been done of the Criminal Act. And when you take a holistic approach at making some of these changes, that would it not be best to incorporate it into one bill, referencing the importance of having those changes take effect? Some of those changes, as I say, are completely mundane and necessary. They're just, who duels nowadays, as an example, being repealed in his comments with respect to that.
The honourable member for St. Albert, Edmonton.
Mr. Speaker, it might have made sense that the government introduced one bill related to changes to sexual assault laws, but this bill does more than that. It would, among other things, require that the Minister of Justice introduce a charter statement with any bill that the minister introduces in this House. It would remove unconstitutional sections of the criminal code, something I fully support. It would remove sections of the criminal code that are redundant, which again I fully support, but again totally unrelated to changes around sexual assault laws. And it would remove sections like Section 49 dealing with protecting Canada's head of state, Her Majesty the Queen. Again, totally unrelated to sexual assault laws. So, Mr. Speaker, this is an omnibus bill, and it is exactly what this government campaigned that they wouldn't do, and here we are debating an omnibus bill.